Hello everyone, and welcome to Taylor Wessing's latest webinar, forming part of our ongoing data protection broadcasts. This is where we bring you our expertise and our views on topical data protection issues. My name's Sally Annereau, and I'm a senior member of the London Data Protection Practice. Those of you who join us regularly will know that we've tracked a wide range of webinar topics over the years, looking at core requirements and practical applications of the GDPR, and sessions where we've looked at the data protection considerations for particular areas like recently on children and ad tech, and cross-border data flows, Brexit of course, as well as topics such as cybersecurity and direct marketing. And past recordings of all of these webinars can be accessed from our Global Data Hub microsite. Today is the second of two webinars where we're looking at the application of the GDPR to life sciences. Today's session picks up from the initial high-level look at those core data protection concepts relevant to life sciences that we considered on our webinar back in February. And boy, quite a lot has happened since then. As we mentioned on that first webinar, life sciences is one of the most heavily regulated of sectors. It already operates within a long-standing and separate framework of regulatory, professional, and ethical standards, which include, for example, the clinical trials regulation, as well as other European and national pharmacovigilance and medical devices legislation. As part of that mix, data protection law will also have a particular relevance where information about individuals, including sensitive health information, will play a key role in activities like research, like the development of scientific knowledge, the exchange of ideas, and the development, the delivery, and monitoring of treatments and technologies. It's in part the nature of these separate ethical, regulatory, and professional frameworks that create specific challenges for the life sciences sector, both in terms of understanding the interrelationship with the GDPR and what it has to say about processing personal information of individuals. As I've mentioned already, this is part two of two separate webinars, and in part one we considered the sort of at a high level the core data concepts. And if you missed that webinar and you wish to revisit the content, a recording of that webinar can be found on our Global Data Hub website. Given the circumstances, we're delivering this to you today remotely from different locations and potentially different broadband speeds, and including a colleague who's joining us from Germany. I am going to offer apologies in advance if there are any slight lag in the slide transitions, or if there's a temporary breakup of audio. Do please bear with us. So, to take a deeper dive around data protection topics relevant to life sciences, I'm joined by a bevy of my colleagues from Taylor Wessing's Commercial Technology and Data Group in London, and as I mentioned, our German colleague from Berlin as well. In particular today, I'm going to start off with a further look into the particular interpretations of those core concepts of controller and processor under the UK data protection law in the context of clinical trials. Then my colleague, Mary Rendle, will then also in the context of clinical trials be considering the challenges of identifying the appropriate lawful bases relevant to processing of personal data. And then following Mary, John David will be looking at the growth of AI and machine learning and data analytics in the healthcare sector in the UK, and considering key data protection compliance issues. And then lastly, Thanos Rammos, a partner in Taylor Wessing's Technology, Media and Communications Group in Berlin, will be looking at the approach of regulators to the use of personal data in life sciences and healthcare, but with a focus on Germany. Firstly, however, and from a data protection perspective, we should perhaps acknowledge the health data elephant in the room, which is COVID-19. Whilst data protection may not necessarily present, present reasons that are going to be at the, compliance reasons at the forefront of a business's priorities at the moment, it is worth noting that issues can arise, and that certainly from a UK Data Protection Act perspective, which does incorporate the GDPR, the law does accommodate the processing where it's necessary to protect a person's vital interests, whether that's the subject or another person, and that might include in context of monitoring and managing the spread of epidemics. It also recognises legitimate interest and substantial public interest grounds for processing. So employers and organisations are clearly going to have an obligation to protect their staff, and in present circumstances it can be reasonable to ask if staff perhaps have experienced coronavirus symptoms, or to respond to questions from health or other authorities involved in tracking. But clearly any such requests should focus on and be limited to what's necessary. The ICO has also published a statement that basically says that it will take a pragmatic approach to considering the issues here. Although that doesn't necessarily mean that there's any kind of compliance holiday whilst we're all struggling with the challenges that we're facing at present. The emergency will give rise to other specific compliance challenges, particularly around ensuring confidentiality and security of processing, such as when working in remote context, or in the enhanced risks that we're seeing from cyber criminals who are seeking to use phishing emails to exploit individuals' anxieties through bogus links and attachments to malware. So the watchword at present is, be alive to the risks and reinforce guidance to staff. And we're going to be publishing some more detailed content on this and the challenges in our next batch of Global Data Hub content in April. So just to get rid of that elephant, and let's move on and turn to the main topic of the day. And I'm going to start, as I mentioned, by considering the roles of controller and processor in the context of clinical research. So just in the context of a research study, there can be different data and different purposes for processing, which are going to be relevant in either case to determining the roles of the parties. So perhaps first we consider research data. And by research data, I mean here the personal data that, according to the study protocol, has to be created, acquired, and analysed in the course of the study. As we considered before on the first webinar, the primary responsibility for processing of personal data under data protection law rests with the controller for the data, which means the entity who alone or with others decides on the purpose and the means, in other words, the why and the how of the processing. In the case of research data, it's the sponsor who decides what data is collected, whether that's through the protocol, the case reports, or the database fields. The sponsor is the sole party who decides what data is collected for the study, and will therefore be acting as the controller in relation to research data. Recent guidance from the UK Health Research Authority, or HRA, in conjunction with the Medical Research Council, reflects this position, making clear that clinical or contract research organisations or trial sites, including hospitals, that carry out the clinical research on behalf of a third party under a contract will be viewed as processors for the research data. As the processor for research, the trial site might still be making quite significant operational decisions, such as what systems are used to process the data, the record keeping, how it's secured, how it's transferred, what retention schedules are adhered to. But these operational decisions still happen under the overarching umbrella of the sponsor's protocol and do not therefore change the status of the site in respect of that data as a processor. The UK Health Research Authority, HRA, and the Medical Research Council also confirmed the view that the sponsor will always be treated as the controller for contract clinical research. That said, in some cases, there will be more than one data controller for research data. So if, for example, in the case of the study, there was co-sponsorship and where the co-sponsors jointly determined the purpose and means of the processing, the study protocol, if both are making those decisions about the data processing relating to the trial, then they can be joint controllers for that research data processing. However, we should also consider other data. So just because a trial site is being treated as a processor for research data doesn't mean that it's not a controller in its own right for other data, in particular for care data. And by care data, I mean here the personal data that's collected or created by the site before the subject is first approached about taking part in a trial or a study. So, for example, that might be the historical medical records. So data for the purposes of ensuring both the patient's care, but also including data relevant to compliance by our sites, such as a hospital with its own separate legal reporting obligations. That data would be data for which they were a controller. Sometimes care data may also form part of the trial, the study protocol, and be shared with a sponsor. In that case, the sponsor is a controller for the shared care data. The site remains a controller in the context of the care purpose for processing. But if it was separately necessary for the site under the protocol to investigate specific care data, then in relation to that specific investigatory processing of care data, it would be a processor for that processing as it's taking place under the protocol. So this position only applies to clinical investigations in the UK, and say we're talking about the guidance here of the HRA and the MRC in conjunction with discussions with the ICO, and we understand that position isn't aligned necessarily with the position of other regulators in other jurisdictions in Europe. So, for example, we understand that regulators in Germany and Berlin may hold to Belgium, may hold to a position of treating the site as a separate controller for both research and care data. So bearing that in mind, understanding clearly that the context of a study and the roles of the relevant parties will be important in terms of ensuring that these are reflected correctly in the contractual terms between the parties, including processor clauses where needed, and in identifying and ensuring correct attribution of responsibilities in any co-controller scenario that's relevant to the processing of care data. So with that, I will now introduce my colleague, Mary Rendle, who is going to talk about lawful grounds bases for processing and the analysis of those relevant lawful grounds. Mary.
Thanks, Sally, and hello everyone. Thank you for joining. I really hope you're all fit and well in these rather strange times. So I wanted to first of all just recap on the basics in relation to lawful bases. To be able to process any personal data in a clinical trial or any other scenario, you need a lawful basis before you do so. You will also need a lawful basis for each processing activity and purpose. It's not a case of one size fits all, and this will apply to all the different types of processing activities that happen in a clinical trial. As you will know, the available lawful bases for processing personal data are set out in Article 6 of the GDPR. Now, given the health data involved, organisations running clinical trials will also need to rely on one of the grounds of Article 9 of the GDPR, which sets out the exceptions available to the general prohibition on processing special category personal data. And obviously the most relevant type of special category personal data in the clinical trial setting is, of course, the health data. A question that we hear a lot when talking about the lawful basis in clinical trials is, do you need consent to process the personal data? Now, if you are a data controller in relation to personal data being used or generated during a clinical trial, under the GDPR, you need to process personal data under one of the lawful bases set out in Article 6. Each processing operation in a clinical trial must be carried out under its own lawful basis. as just mentioned, you cannot select a single lawful basis to cover all the data processing that is happening during the trial. Consent is one possible lawful basis listed in Article 6 of the GDPR, and there has traditionally been a focus on patient consent in the world of clinical trials. This is because informed consent, as you all will know, must be obtained before a patient can participate in a clinical trial under the Clinical Trials Directive and then the Clinical Trials Regulation when it comes into force. Confusion often arises because some quite logically think that because you have collected informed consent, this means that consent will automatically be the lawful basis for processing any personal data under the trial. However, we do need to remember that the Clinical Trial Directive informed consent is in fact quite different to GDPR consent. The GDPR sets a much higher standard for achieving valid consent and requires that it is informed, specific, freely given, and involves an unambiguous indication of the data subject's wishes. If you are also relying on consent as an exception to that general prohibition on processing special category data, including health data, consent also needs to be explicit. So this is really quite a high standard of consent. I should also point out that the freely given element of GDPR consent means that if there is any sort of power imbalance between the person giving the consent and the recipient, then that consent will not be freely given. This is where clinical trials do run into an issue. It is likely that a trial participant will be motivated to enter the trial because they need access to a medicine or because there's some kind of financial incentive, meaning that there is this imbalance of power and the participant's consent is not freely given. Another issue in using consent in clinical trials for GDPR purposes is that consent must be capable of being withdrawn without detriment to the data subject at any time under the GDPR. And this will clearly be problematic if a participant withdraws their consent halfway through a trial. The UK's Health Research Authority guidance actually goes further and explicitly states that consent is not an appropriate basis for the processing of personal data in clinical trials for research purposes. However, this approach does differ across different jurisdictions, as Sally has mentioned. So if you are conducting a trial that, as many do, crosses different member states, there may be a different approach in relation to consent, and you will have to consider this. So as I've just run through all the different complexities of obtaining and relying on valid GDPR consent in a clinical trials context, and of course the HRA guidance in the UK, it's clearly not the most appropriate lawful basis in the UK on which to rely when processing personal data in the clinical trial setting. So what is the best alternative approach? Now, as mentioned, to decide this, we need to separate out the processing purposes that are involved in the clinical trial. We need to be really granular. Clarification in relation to the data protection elements in the clinical trial landscape was offered last year by the European Data Protection Board in its opinion of January 2019. And this actually covered the interplay between the new clinical trials regulation and the GDPR. But it really offered some great guidance on selecting the lawful basis for processing personal data in clinical trials. The opinion suggests that the processing purposes of a clinical trial can clearly be set out into two different types. The first type being the primary purpose of the protection of health, and the secondary purpose being the research activities involved in a clinical trial. And the opinion states that these two distinct purpose types will have different lawful bases. According to the opinion, the most suitable lawful basis on which to rely with regard to that primary purpose of the processing in clinical trials, being the protection of the health of the participants, will be that the processing is necessary for compliance with a legal obligation, and this comes from Article 6(1)(c) of the GDPR. So, for example, the legal obligations around safety reporting in the clinical trial and providing care to the participants. For this primary purpose of the processing, the relevant Article 9 exception to the prohibition on processing special category personal data will be that the processing is necessary for reasons of public interest in the areas of public health, and that comes from Article 9(2)(i) of the GDPR. Now, moving on to the secondary purpose of the clinical trial, which the European Data Protection Board identifies as being those research activities. These research activities require a slightly more complex analysis to decide the appropriate lawful basis. The opinion clearly states that the processing for these purposes cannot be based on compliance with a legal obligation, and it goes on to consider the three other options available for the lawful basis for this processing, being the public interest basis, the legitimate interest basis, and consent. However, the opinion states that consent will not be the appropriate legal basis in most cases, which is in line with the HRA's guidance in the UK, as I've previously mentioned. So, by ruling out consent as the lawful basis for the processing for the purpose of the research activities in the clinical trial, we are left with those two lawful basis options, the public interest and the legitimate interest. This means that the lawful basis for this purpose will usually be for the performance of the task carried out in the public interest, if the controller is a public authority, or because it is necessary for the pursuit of the legitimate interest of the controller, where it is a private body. But always remember that this is a balancing test, and that you have to ensure that the legitimate interests of the controller prevail when balanced against the privacy rights of the data subject, who in this case is the clinical trial participant. And for the processing purposes for the research activities in the clinical trial, the most relevant Article 9 exception is likely to be that the processing is necessary for archiving purposes in the public interest, scientific or historical research purposes, and this comes from Article 2(j) of the GDPR. Now, if you are relying on the exception set out in Article 2(9)(j) of the GDPR, which is that the processing is necessary for the scientific purposes in the case of the clinical trials, you do need to remember that Article 89 of the GDPR also applies, and that personal data used for research purposes must be subject to appropriate safeguards that respect the principle of data minimization, such as pseudonymization, which is something that already happens a lot in the clinical trial setting anyway. Article 89 also allows for member state derogations, and in the UK, the Data Protection Act 2018 states that such processing of personal data for research purposes must be in the public interest. We are currently awaiting guidance on what this means in practice, but in the meantime, our interpretation is that it does not necessarily exclude clinical trials that have commercial elements, as long as there is also a public interest in the clinical trial. Finally, I did just want to touch upon coronavirus and the sharing of health data in these uncertain times in relation to the lawful basis. And I just wanted to make the point that generally the sharing of health data about COVID-19 is unlikely to be prevented by data protection legislation, because it will fall under lawful bases such as the protection of vital interests, public interest, legitimate interest, obviously depending on who the controller is, and also the Article 9 exception that sharing is in the public interest in the area of public health. However, please always remember that the usual data protection principles apply, so consider elements such as not sharing more information than is necessary, obviously keeping the data secure at all times, and whether you can anonymize the data as far as possible when sharing it to protect the identity of the individual. I should also just briefly mention that the sharing of personal data is mentioned in the coronavirus bill that is, as we speak, swiftly making its way through Parliament and has its first reading in the House of Lords this evening. We will obviously keep you posted on this and the implications. And as Sally mentioned, we've got some upcoming information about coronavirus generally and data protection that's coming out in April. So now I'm going to pass you on to my colleague, Jean-David, who's going to talk about AI in the clinical trial setting.
Thank you very much, Mary. And we could probably spend a full session on AI and healthcare, but for the next 50 minutes or so, I will focus on 3 areas. The first one will be a brief presentation of the level of investment in AI and healthcare. I will then give you a picture of the AI trends that we've seen in the sector, together with a presentation of the initiatives from various governments around the world, the industry, and the academic sector as well. And finally, I will go through some of the data protection and security challenges which occur on a regular basis when dealing with AI and machine learning. We'll also touch on the recent ICO's AI guidance, which have been issued last month. But let's start first with some graphs and figures, which have been provided to us by the Technician report, which have been issued last week. These graphs give a sense of how attractive AI businesses are from an investment perspective. So, as you can see on the graph on the left, AI represents the highest global investment in emerging technologies, followed by robotics, cybersecurity, and blockchain. And in fact, the Technician report tells us that the US attracted 56% of global AI investment in the last 5 years, followed by China, and then the UK being in the world the 3rd place for level of investment and 2nd by deal count. And the only country actually of the top 5 AI countries to have demonstrated year-on-year growth for the last 5 years. The UK is a 3rd in the world for tech investment for another year running, and as I said, behind the US and China, and raising more than France and Germany combined. Looking at the next slide, which is very specific to AI and healthcare. So again, we can see that America and Asia are leading the way, and that Europe is not far from Asia. And the trend again is confirmed that the healthcare sector is extremely attractive and dominates the investment across the globe. We've put some examples here on this slide that includes probably the biggest investment so far, Babylon Health, which happened last year, as well as CMS Surgical. Others are not on this slide, such as investment received by Kiran Medical Technologies, but also ISO Digital Health last year, and more recently this year, Digital Touch Surgery. So, in terms of the applications of AI and machine learning in the healthcare sector, what we've tried to do here, we tried to give you a picture of the areas where AI is applied in the healthcare sector, and also the initiatives which have been implemented by several countries and regulatory activity as well. So the application of AI has been implemented in every area of the healthcare system, including primary, second, and tertiary, by all types of providers, including private, and that includes startups, but also corporates in the pharmaceutical sector, for instance, and public sector as well, such as hospitals, trusts, which are working together with the private sector and, of course, the research sector. One example that I have in mind is Genomics England, who are dealing with genomics data, and which is the key to unlocking the benefits of precision medicine with AI. And machine learning is already being used to automate genome quality control, and AI has improved the ability to process genomes quite rapidly and to high standards. It can also now help improve the interpretation of the genomes. And Genomics England currently contains over 100,000 genomes and over 2.5 billion clinical data points. And what they have done is they have developed a platform to capture the amounts of data from automated genome sequencing and healthcare professionals that AI needs. And so what happens is that they've got a team of researchers who are using machine learning methods to identify genetic mutations, signatures associated with certain cancers, for example, helping to identify and classify types of disease and to identify targets for new treatments. And there are a lot of examples that we could take, and one of the examples that I have in mind is operational efficiency, whereby platforms have been used to improve the efficiency of the services of the NHS. For instance, I'm thinking of Babylon Health, who have created a platform again. I'm thinking of King's Hospital Foundation Trust together with the South London and Mosley Hospital, who have developed an open source real-time data warehouse tool that is called CogStax. That is used to provide a more efficient way to clinical code and improve financial and operational efficiencies for providers throughout the NHS. So there are a lot of examples, and the example of the slides here is extracted from the NHSX artificial intelligence report that they published last year, which gives you a flavor of the areas where AI is implemented. And here you can see, for instance, the area of diagnostic, knowledge generation, public health. I just mentioned system efficiency and P4 medicine. So this is just a picture of some of the areas where AI has been implemented. And we see a lot of AI and machine learning applications being used again. And we're working with some of our clients to try and help them assess the risk from privacy perspective and cybersecurity perspective as well. I could give you a lot of examples, but just in the test of time, I'm going to carry on with the rest of the presentation and focus on the various initiatives. And obviously, Sally and Mary mentioned COVID-19, and we've seen initiatives from various organizations to continue to respond to the COVID crisis. And in particular, we are aware that the NHS is working with Google, Twitter, Instagram, and Facebook to provide the public with accurate information about COVID-19 and prevent the spread of fake news on their platform. So what that means in practice is that the social media platforms have increased the volume of AI and machine learning capabilities to monitor content on their platforms and to allow them to take some actions to ensure that accurate health advice is provided. Facebook also has announced last week that researchers are using aggregated and or anonymized data, Facebook data, including mobility data and population density maps, to better understand how the virus is spreading around the world. That was the business side of things, but in terms of research and academics initiatives in relation to COVID-19, last week the US White House announced an open research dataset challenge in collaboration with tech companies and academics to make COVID-19 research accessible to AI researchers and their algorithm with a view to find a vaccine for the virus. So they have an example, but just to tell you already that, you know, to respond to the pandemic, a lot of companies have put together resources and implementing AI capabilities to ensure that they can help on the health side. Now, there are a lot of AI papers out there. Some are generic, some are specific to data protection. In Europe, there is a list of position papers which have been published on the website of the European Commission, and they tell you about what each country has done with respect to AI. There's one for the UK, there's one for France and Germany and other countries. But also in Canada and the United States, position papers have been issued 2 years ago by Canada and last year by the United States. On the data protection side, we are aware that some data protection authorities have also taken the initiative to issue some consultation papers or some guidance. So in Europe, for instance, the French data protection authority, the CNIL, 2 years ago issued some recommendations in relation to AI and ethics. Last month, the Spanish data protection authority issued guidelines on AI as well, and there is a Spanish and English version available. And last month, the UK also issued its draft consultation guidance on AI. So it's not specific to the healthcare sector, but when going through it later on, I will tell you what takeaways we should take from the guidance issued by the ICO. In the UK, so a lot of initiatives have been implemented, and I'm thinking, for instance, of the UK government's industrial strategy and the AI sector deal, and more specifically to the healthcare sector. A report has been issued, which is very specific to life sciences, which is called Life Sciences Sector Deal. And what happens at government level is that they have implemented or contracted with the industry, and they have built partnerships with some private companies to make sure that they collaborate, one, with the industry, and two, with academics as well. There are also actions from the industry. I'm not going to mention them all because they're on the slides, and so look at them in your spare time. And also AI bodies have been created. Probably one of the most important one is the Alan Turing Institute, and also an AI committee which have been instigated 2 years ago. The ICO has been quite active as well, and what they've done is they started working on AI issues in 2017, and they have also developed some projects such as the project Explain, and leading to their consultation that they have published last month. So it's quite involved both at a European level, but also in Canada, the US, in China, India, and other countries as well. And there are sectoral regulatory activities as well, which have been issued by some authorities. Now coming to the meaty bit of the application of AI, I just wanted to give you a flavor of what we've seen, and the first point is that we are aware of an investigation which involves the use of AI in the healthcare sector, which is now closed, and involves the use of Google DeepMind's streamed application at the World Free NHS Foundation Trust. And at the time, the ICO concluded that the processing of approximately 1.6 million patients' personal data by DeepMind for the purposes of clinical safety testing of the streams application, did not fully comply with the requirement of the old protection law with the Data Protection Act 1998. So since then, so last year, the ICO procured an undertaking and from the World Free Trust to fulfill a number of requirements and implement third-party audit recommendations commissioned by the Trust. And last year, the ICO said that it was happy with the actions implemented by the Trust. So now I'm just going to briefly go through the ICO consultation of the draft AI guidance, just to tell you a little bit about the issue that we see as well when an AI system is being implemented. So what the ICO has done is that they've been working on AI issues for a while, and they've developed a framework for auditing AI, which provides methodology to audit AI application and ensure that organizations process personal data in accordance with the GDPR and the DPA 2018. So what the guidance does is that it provides auditing tools and procedures that the ICO will use in these investigations, and includes some risk assessment and control measures that you can deploy when using AI to process personal data. And so just in the interest of time, I'm just going to focus on 3 or 4 points here on my slide. And the first one is about accountability and governance measures. As you know, the GDPR is structured around the principle of accountability. And when it comes to processing health data, the importance of implementing good accountability measures is higher because of the sensitive data that you are dealing with. And so when you act as a controller, you are going to be responsible for the compliance of your AI system. And what we have noticed is that there is sometimes a disconnect between the technical teams and the rest of the business deploying the AI system, which can lead to gaps in the governance measures in place, and therefore data protection measures can be sometimes loose and do not always meet the GDPR requirements. So what is important to meet the accountability principle is that it's very important to fully understand the AI system that you are creating and are deploying to meet your obligations under the GDPR. And this includes working with all the teams involved in the deployment of the system, having a full picture of the personal data flow that may involve creating a data mapping, for instance, creating effective controls for individuals to exercise their rights, such as the right of access or the right to erasure, which are particularly tricky in the AI context, and implementing governance measures which involve senior management to review and monitor the decisions made by AI about individuals. Also on the accountability point, other measures could include implementing and documenting what we call a DPIA, or data protection impact assessment, to assess and document the data privacy risk associated with your use of AI. And if you are in the UK, for instance, the ICO guidance says that you will be required to carry out a DPIA to assess and mitigate potential risk for individuals before beginning the processing of any personal data when using any AI system. I'm not going to mention or talk too much about the roles of control and processor because Sally talked about it earlier, but I think the only point that I just want to mention is that in the AI life cycle, the roles can change quite easily, actually. So it's possible that a processor may act as a controller when wanting to reuse the data for training the algorithm, for instance. That's not uncommon. And the ICO, in its guidance, have been very clear on that point and said that it's very possible for it to happen. And the key is for you to make sure you identify your role at the outset of a transaction, document it very clearly in your agreement, and if the situation changes, then you can come back to the agreement and amend this if necessary. A very interesting clarification made by the ICO in its guidance actually is that an organization can take certain decisions about data and models and that organization may still act as a processor, which is rather unusual because usually an organization taking decisions is going to be a controller. But it's possible that if you take some type of decisions, you may be considered to be a processor. The key here is that you will be a controller if you have sufficient influence over the essential elements and purposes of the processing involved in the prediction, and if the decisions that you take are not overarching as well. That's the key here. So the UK guidance gives you some examples actually about when and how you act as a controller and our processor, so have a look at it. The Spanish GDPR also provided a table giving you some examples as to how and when you will act as a controller and our processor. The next point is also extremely important, which is transparency and lawful basis. Again, I'm not going to tell you too much about it because Mary covered it quite widely earlier. But I think the key takeaways for me in the AI context is that it's very important to identify the most appropriate lawful basis for processing health data. And remember, as Mary said earlier, when you process health data, you will have to identify both lawful basis under Article 6 of the GDPR and a separate condition for processing under Article 9, and consider the GDPR and national exemptions where applicable. So obviously issues may arise, and it may be difficult to identify the original controller of the data depending on the source of the data that you use, and we know that some companies will collect data from various sources, including public sources, whether in the UK or in the US, to make sure you comply with the conditions around the use of that data if you intend to use it for your own purposes. Very important also to document your lawful basis in your Article 30 document, and to inform individuals about what you do with data and how you're going to use it. Last point, which is quite important as well, is the importance of security. So the healthcare sector is actually one of the industry sectors which is the most affected by cyber attacks and personal data breaches. I'm sure you all remember of the WannaCry attacks on the NHS. And to us, it just showed that data security and cyber incidents can disrupt healthcare systems and directly contribute to patient harm. So it is very important that robust technical and security measures are implemented, and that should be linked with the GDPR that you are going to implement as well. Managing trade-off. So trade-off is a term that the ICO uses. Is basically a term that describes competing interests, for instance, ethics and AI, and other interests which are outside the scope of data protection. I don't have time to go into the details of what this trade-off could be, but one example could be, for instance, the discrimination and bias when decisions are made based on the data available to an AI system, which is either not accurate or is not enough to provide the outcome that you necessarily want. And this is a concern that has recently been raised in relation to facial recognition, for instance, technology, which, due to the data on which it has been fed, is far more likely to generate false positive results when identifying women or those with non-white skin tone and features. So there are a lot of examples that show that there's more to it than data protection, and it is very, very important for you to manage what the ICO calls trade-off. Now I'm just going to hand over to my colleague Thanos, who is going to tell you about what's happening in Germany in the life sciences sector.
Thank you very much, John David, and thank you, Sally, for the kind introduction at the beginning. I am Thanos. As Sally introduced me, I'm a partner in Taylor Wessing's Berlin office, so hello from Germany. And I'm going to speak only briefly towards the end of this webinar about some regulator statements both in Germany and in the EU on healthcare and life sciences. as you probably all know, we have seen quite early on a few statements by regulators on life sciences and on the processing of health information, which, as you surely all know, is sensitive information under the GDPR. And in Germany, everybody who has ever had business in Germany knows that we have not only one regulator like in the UK or France with IECO or the CNIL, but unfortunately we have for every federal state a separate regulator. So we have seen many more guidances and decisions and statements by regulators than anywhere else in Europe. But fortunately, we have the Joint Committee of the German regulators, the Datenschutzkonferenz, or DSK, that issues also joint decisions. So we get some more streamlined guidance from that perspective. As I said, we have seen many guidance papers on life sciences and healthcare, but there are still a lot of open questions in all areas where medical or health data is being processed. In particular, digital health services and the use of software based on big data and AI have also attracted attention of regulators. And if you want to have a specific German aspect to similar items of what John David just talked about, I'm happy to answer these later on over email or via phone. So please feel free to reach out to me. We have seen specific AI guidance here, and regulators have been quite keen to stress that AI implemented or used in the healthcare or life sciences space needs particular attention, and there is detailed guidance to that. A recurring theme from regulators in addition to that is that despite some efforts to adapt to the new regime under the GDPR, the level of data protection is still lacking in this area. So from the perspective of most German regulators, it can be said that companies are not doing enough. Another focus which seems to be of particular concern to regulators are mobile health services. The Joint Committee of German Regulators has issued a white paper dealing with technical and organizational measures in this field, and has also issued guidance in terms of using websites or using messaging apps within healthcare companies, and also addresses the high risk of abuse of personal data that contains sensitive health information. So there is a focus, or rather a high attention to all this. In addition to that, we've seen guidance from the European Data Protection Board, partly guidance that Marie already has talked about, but also some other aspects. And finally, there is additional guidance from governmental agencies. You can see some of that on the next slide. I'm just going to talk about a few of those, and I'm happy to answer more questions via email or else. So as Mary said, the European Data Protection Board has issued a key opinion concerning the interplay between clinical trial regulation and the GDPR, but still questions remain regarding the roles and responsibilities in clinical trials. Kelly had touched on this, and I think we've already seen the question coming in from the audience, which is very interesting. Aside from this, several EU non-governmental and German governmental agencies have also addressed the requirements to be met in terms of data protection for health service providers by way of specific guidelines. One of these is the guidelines on the protection of health data issued by the German Federal Ministry for Economic Affairs. That is particularly interesting because it aims to provide an introduction to the GDPR's requirements for developers and suppliers of digital health products. So you can see that the German government is actually trying to further or to push or to help these providers of health apps or similar services to be compliant with the GDPR, at the same time supporting them to develop new products. In this guidance, the BMWI, how we call it, the German ministry, outlines the impact of the GDPR on some key issues in specific areas, for example, also automated decision-making, big data application, and the development of apps. So you can see there is a lot of movement in this space. And finally, not to leave out COVID-19, We have talked and you have seen the EDPD guidance on COVID-19, but also the German regulators have come out with a statement recently and said that the processing of employee data, the processing of data of guests or of other persons that may be visiting a hotel, etc., is compliant and can be justified under the GDPR, but that data minimization, etc., transparency, other principles have to be taken into account. So moving on from that, from the statements to enforcement and fines, we can say that actually there are across Europe, as you can see on this slide, quite a few fines in the healthcare and life sciences space. The majority, can be said, are more on the healthcare side rather than on the life sciences side. But you can see what I discussed before. There is a focus, there is an attention to this particular sector. So you should be careful. In terms of enforcement in Germany, the most recent fine was in the context of a patient mix-up when admitting the patient. And this resulted in incorrect invoicing and revealed structural, technical, and organizational deficits in the hospital's patient and privacy management. And from that, you can understand that there is a specific focus at the moment on rather that part of the processing than on others. So it can be said that getting your technical and organizational measures in place and probably getting all the customer-facing documentation in place, such as privacy policies, consent declaration, will mitigate the risk considerably. What we also should say, though, that it's not all about fines. Regulators in Germany and I think across Europe are increasingly relying on a naming and shaming as part of their enforcement strategy. So they realize that the threat of reputational damages is of concern to most companies, and they're trying to use this in addition to any fines they issue. And we had a recent case in Germany where a health app was actually using tracking technology, and that was done without consent. And the regulators did not wait long to name this company publicly, which led to quite a big backlash for this company. So overall, it should be taken into account that even if you get away without a fine, your business model, especially in the healthcare space, is endangered if the regulator starts calling your name out in the press, and that will not go away for quite a long time. So that's a very short roundup of the enforcement and fines and the regulatory statements in the EU and Germany. And with this, I hand over to Sally, and thank you all for your attendance so far.
Thanks very much, Thanos. So we are nearly at the end of our time today. If you have any questions about today's topic, data protection, Taylor Wessing in general, just to mention that we are an international law firm and we provide a full service law firm, not just in data protection terms. Our footprint spans across Northern, Central, Eastern Europe, and our data protection practice is equally international in scope, which is a global 22 partner-driven team complemented by the broader international network of privacy specialists. So if you do have any particular issues or questions, do let us know. On the topic of the seminar, the webinar today, we've had a couple of slightly more technical questions, particularly around different scenarios where the controller processor relationship might play out in the context of a clinical trial. I think what we'll do, given the time that we're now at the end of the hour, we will follow up with those attendees by email in relation to those specific questions. But thank you for those, and we will follow up with you directly on those specific questions. Another place you can go to for more information, I think we mentioned already, is our dedicated micro site, which is for all things data protection, our global data hub. And there you can find more information, our weekly news updates and our bi-monthly mail shots if you register, topical issues, including life sciences, including topics around medical devices as well, where we take a look at the issues and the concerns of raising particular privacy challenges. You'll also find details of our forthcoming webinars along with recordings of our archived webinars. if you want to revisit the content. The Global Data Hub site is also where you can access checklists and tools. There's also our Global Data Protection Guide, which allows you to compare national data protection laws of more than 60 countries against each other. So take a look at that. And we also have our cyber response app, which more details available on the microsite, which is developed to help companies prepare more easily and react more effectively and quickly to a data breach incident. So with that, I just wanted to let you know, as you say, that the recording of this webinar and slides will be shortly available on that Global Data Hub microsite, and you can access that and the details of the future webinars. So thank you for joining us today. It's just left for me to thank you for your time with us, and we hope you will join us again. Goodbye.